Good afternoon, everybody, and welcome to the Five Stone Buildings webinar programme. Just like to remind everybody that these webinars are recorded. So if you have any questions, or you can use the Q&A box to put your questions in there. If you don't want to be identified in your response, then please click the anonymous box and our speakers will not identify you when responding to your questions. And I'll hand over to David.
Well, actually, I think we're going to hand over to Sarah.
Sarah?
Yes, good afternoon, everyone, and welcome to this Five Stone Buildings webinar on the topic of litigation friends. It's being presented, as you can see, by David Rees, QC, and by me, Sarah Haren. We both practice in areas which involve lots of cases involving litigation friends, and David in particular has recently appeared in the important decision of Hinduja and Hinduja, in which the court had to grapple with some of the technical formalities with how one becomes a litigation friend, and also with challenges to the suitability of a litigation friend. We're going to aim to speak for about 45 minutes, and as Joe's explained, if you do have any questions, please do put them in the Q&A box and we'll try to answer them. And if you're watching this live, we have to say thank you very much for eschewing the sunshine and favouring us over sitting outside. We are indeed flattered. So, Joe, could we have the first slide, please? So, first question is, who needs a litigation friend anyway? Now, the procedure for the appointment of litigation friends is obviously found in Part 21 of the Civil Procedure Rules. And there are two categories of litigants who need a litigation friend. The first is children under 18 years old. There is an exception to this, which is that the court does have the power to permit a child to litigate without a litigation friend. And in that respect, children are different from the other category of litigants who require litigation friends. That is, protected parties. Now, I don't know about David, but I've never had a case where a child has not had a litigation friend. And I certainly think in the sorts of litigation that we tend to be involved with, so disputes about trusts and estates and property, it's pretty unlikely that the court would dispense with a litigation friend for a child. It's possible, though, I suppose, particularly if a child is on the cusp of attaining majority and the issues at stake are such that it is possible for the child to reach a considered view by him or herself. But I think that's extremely unlikely in practice, at least in this sort of field.
Can I throw in a thought there, Sarah?
Yes, of course, David.
Which is, I think this is most common in family proceedings.
Yes.
The family proceedings rules have very similar provisions, and it is more common for a child who is GILIC competent and able to understand the issues and provide instructions to solicitors to be independently represented. I think I have seen it happen once in Chancery style proceedings, which was a variation of Trust Act application, I think. But that was a case, if I remember correctly, where the child in question was only just shy of their 18th birthday.
Thanks, David. Yeah, so that sort of accords with my my understanding, really, of how it works in practice. So, protected parties also require a litigation friend, and a protected party is somebody who lacks capacity to conduct the proceedings, the claim in question. Now, it's possible, I should say, that a protected party might, in theory, have capacity to bring or defend one sort of claim, but not another. Again, I think this is likely to be pretty rare in practice, but I did have a case, which I mentioned to David earlier, where a protected party in a 75 Act, an Inheritance Act claim, she didn't have capacity to conduct that set of proceedings, but she had capacity to conduct some very straightforward divorce proceedings where there were no sort of financial remedies at issue because the parties didn't have many assets. So it's just about possible. But again, if protected party if she can't conduct litigation, will need a litigation friend. Capacity is function specific, of course, so the fact that a person might lack capacity to manage her property and affairs or make a will doesn't necessarily by itself mean that they lack capacity to conduct litigation. But, I mean, litigation is normally a pretty sort of high, requires quite a high level of decision-making powers, because of course you have to be able to evaluate the advice or the situation as it develops and make decisions as you go along. Now, why is it so important to have a litigation friend? Why does it matter? Well, I think it's absolutely crucial because of the consequences of not having a litigation friend. And those are really twofold. First of all, under the rules, as we'll come on to see, any step taken in litigation before a child or protected party has a litigation friend is generally without effect unless the court permits it, which it can do retrospectively. But you might find that a lot of orders that have been made and a lot of things that have happened are simply nullities unless your party has a litigation friend. That's one reason. And the second reason why it's so important is that when it comes to compromising a claim, which the compromise is reached with a person who requires a litigation friend, the court's got to approve it before that compromise is valid. And the Supreme Court decision in Dunhill and Bergen makes clear that it doesn't matter if the other party to the compromise doesn't realise that a litigation friend was necessary. For example, didn't realise that the other party lacked capacity. The compromise is still not valid. So you could find yourself years after the event with a compromise which is being effectively unwound when the protected party recovers capacity or somebody else takes over the conduct of their affairs and discovers that a compromise which was not in their best interests has been reached. So that's why it's really important, even for parties on the other side. As for solicitors or representatives acting for somebody who may lack capacity, well, beware, because if it's later found that your client lacked capacity, there is some quite old authority called Young and Toynbee from the early 20th century, which suggests you're effectively warranting your client's capacity. And so if that turns out to be wrong, you could end up being on the hook for some of the costs. So it's really important to grapple with these issues as soon as they occur. So what do you do if you suspect that particularly the opposing party lacks capacity and you want to sort this out? Well, it's quite difficult, but you must raise it. I mean, if you have a genuine concern, first of all, with the other party or their representatives, and if necessary, with the court. And indeed, the court itself might form the view that there is a doubt about capacity that it independently wants to investigate. And I think, David, you said earlier, didn't you, that the guidance to the judiciary is that it's something that ought to be raised if you have a concern about capacity.
Yes, I mean, it's set out in the Equal Treatment Bench Book and makes clear that judges should independently consider this, not least because the Bench Book makes clear there are concerns that legal advisors, particularly in areas other than cases which often involve people who lack capacity, may simply not have experience of dealing with people who lack capacity, or may not be live to the issues, or may not be live to the sorts of behaviours that ought to trigger these sorts of investigation.
I think it's fair to say, I mean, that's right, and having, you know, in an appropriate case, a judge will obviously want to be reassured that that the litigants have capacity. There may be, I mean, it will also be perhaps a little sceptical, though, of these points being raised for potentially tactical reasons. And so normally, as long as you can show that a represented party, that their representatives have really properly considered the issue, the court's not likely to go behind the view that the representatives have formed, the issue having been raised and it having apparently been given good consideration. The other sort of tricky aspect of it is that the court doesn't have a power to require a litigant to undergo a capacity assessment, but I suppose it can come up with potentially, can strongly encourage it and potentially at least produce with that encouragement a result where it is satisfied of the litigant's capacity or lack of it. So that's why it's absolutely crucial to sort out the question of the appointment of a litigation friend. So Jo, could we move to the next slide, please? So having worked out why you need a litigation friend and in what circumstances, the next issue is how a litigation friend is appointed. And the first way in which a litigation friend can be appointed is without having to involve a court order or getting a court order in the proceedings. And there's a distinction to be drawn here between the position of protected parties who've got a deputy authorised to litigate and everybody else. So if you're dealing with a protected party, your first question is, well, do they have a deputy for property and affairs? If yes, does that deputy have authority to litigate? And this is a very important qualification, because under the standard property and affairs appointment order, it doesn't give a deputy authority to litigate. And the circumstances when such authority might be given and in what circumstances that deputy might be permitted to instruct his or her own firm have recently been considered by the Court of Protection in the case of ACC, which David and Ruth did a webinar on earlier this summer. So I would encourage you to well, either read the case or probably better still, watch David and Ruth's helpful webinar on that. So if you've got a deputy who is authorised to litigate, then that deputy is entitled to act as litigation friend and must file a copy of the order which authorises them to act with the court in which the sort of civil litigation is taking place. And they've got to file that when they're acting for the claimant at the time the claim's made, and when they're acting for the defendant when when the litigation friend first takes a step in those proceedings. And we'll come back to the importance of the timing of all that. So that deals with deputies authorised to litigate. In all other cases, you can be appointed, or rather you can become a litigation friend without a court order by filing a certificate of suitability. Again, the timing of filing that certificate of suitability mirrors that of the deputyship order. So it's when the claim's made at the time you're acting for a claimant, and when you're acting for a defendant when the litigation friend first takes a step in the proceedings. And that certificate of suitability has got to confirm three things which are set out in 21.4 subrule 3. And those three things are that the litigation friend can fairly and competently conduct the proceedings on behalf of the child or protected party, that they have no adverse interest to that of the child or protected party, and thirdly, that where the child or protected party is a claimant, that they undertake to pay any costs which the child or protected party may be ordered to pay. Now, David's going to look at the first two criteria in a moment, and I'll come on in due course to talk about C, the liability or the undertaking to pay costs. So that's the procedure without a court order. Jo, could we move to the next slide, please? So if you haven't gone through the procedural hoops for an out-of-court appointment, then you need a court order for your litigation friend to be appointed. And the application for the appointment of litigation friend can be made by either the prospective litigation friend, him or herself, or by any party to the proceedings. And actually, in certain circumstances, the claimant is obliged to apply for a litigation friend, namely if he wants to take a step in the proceedings other than service, or if someone who's not entitled to be a litigation friend has filed a defence. Not quite sure why it says not entitled as opposed to not a litigation friend, but in any event, in those circumstances, the claimant must apply for the appointment of a litigation friend. And the court, well, first of all, has got to be satisfied that in the case of a protected party, that the person lacks capacity. It's worth noting, although the court's got to be satisfied of that, it can be satisfied by evidence other than direct medical evidence. And I think that was an issue in Hinduja, wasn't it, David?
Yes.
The other thing the court's got to be satisfied of, or rather the court must not appoint a litigation friend unless it's satisfied the person must fills the criteria set out in 21.43, those three matters that I outlined before: fairly and competently conduct proceedings, no adverse interest, and in the case of the claimant's litigation friend, an undertaking to pay costs. So I think that takes us on to David, who's going to talk in a little more detail, or rather in some detail, about what happens when the procedure for appointment goes wrong, out of court appointment goes wrong, and the implications of the recent decision in Hinduja.
Thank you, Sarah. Joe, can we have the next slide, please? Just before I move on to issues of timing, just to pick up on the point Sarah's just been talking about, the certificate of suitability that is prescribed by the CPR has at its top essentially a statement that the potential litigation friend knows or believes that the claimant or defendant is a child or lacks capacity to conduct the proceedings. That's a standard statement that needs to be in there. And then you're asked to explain why, or what is the basis of your knowledge and belief that in the case of protected party, they lack capacity. And the practice direction to part 21 says that if it is based on medical opinion or the opinion of another suitably qualified expert, you need to attach any relevant document to the certificate. But otherwise, there is no requirement for medical evidence. And that was one of the points that arose in the Hinduja case, where the prospective litigation friend had simply explained why she considered the claimant to lack capacity to conduct the proceedings without providing any medical evidence, and the court held that it was satisfied on the basis of that explanation and didn't need medical evidence in order to satisfy itself. This is quite an important point, of course, because it is a matter for the court as to whether somebody lacks capacity to conduct proceedings or not. It's not something that can be agreed between the litigation friend or prospective litigation friend and the other parties to the proceedings. The imposition of a litigation friend is an important and serious interference with the protected party's Article 6 rights to a fair trial. And therefore it is essential that the court itself is satisfied that there is a lack of capacity and that it's not just something that's been stitched up by way of agreement, while leaving the prospective protected party out of the loop. Now, as Sarah's already indicated, it is absolutely essential where you have a protected party that there is a litigation friend in place. And Rule 21.3, which Sarah's already touched on, makes clear that if you have a child or protected party, you can't make an application against them before proceedings have started, or do anything within the proceedings other than issuing the claim form itself and then applying for the appointment of a litigation friend under Rule 21.6 until the child or protected party has got a litigation friend in place. And equally, if at any point within the proceedings a party loses capacity, no party is entitled to take any further steps in the proceedings without the permission of the court until a litigation friend has been put in place. And Sarah has already touched on Rule 21.34, which is that any step that's taken before a child or protected party has a litigation friend is of no effect unless the court orders otherwise. And that rule is, and this is something that the Supreme Court mentioned in Dunhill and Bergen, is just as much for the protection of other parties as it is for the protection of the protected party themselves. And if you don't have a litigation friend, there are obviously risks of applications being made to set aside the judgment. And two of the very well-known cases in this area are both instances of that. Masterman Lister, the leading case on capacity to litigate, was one where an application to set aside a previous judgment failed. But Dunhill and Bergen, the decision of the Supreme Court Sarah's already mentioned, was a case where an application in those terms succeeded. Now, as Sarah's also mentioned, under Rule 21.5, there are specific timings set out as to the filing of documents, either the deputyship order or the certificate of suitability, if somebody wants to become a litigation friend without a specific order of the court under Rule 21.6. And Rule 21.5(1) makes clear that anyone who wishes to act as a litigation friend must follow the procedure set out in this rule. And then 21.5(2) explains that if you're a deputy, you must file your order of the Court of Protection giving you authority to litigate if you're acting as a litigation friend for a claimant at the time that the claim is made, if you're acting for litigation friend as a defendant, at the time when you, and that is the litigation friend, first take a step in the proceedings on behalf of the defendant. And similarly, if you're not a deputy and you're wanting to rely on the filing of a certificate of suitability, the times are the same. So at the time the claim is made, if you're going to be acting as litigation friend for a claimant, or at the time you first take a step in the proceedings, if you're acting as litigation friend for a defendant. And this was the issue that arose in the case of Hinduja and Hinduja, which was a decision of Mrs. Justice Falk. And she handed down judgment in this case earlier this year, in fact, the end of June. The neutral citation is 2020 EWHC 1533 Chancery. And this was a dispute involving the Hinduja family. The claimant is the patriarch of the family, and his daughter was seeking to act as a litigation friend for him and was bringing proceedings against other members of the family. And the daughter issued proceedings, and it stated in those proceedings that she was acting as litigation friend. But what she didn't do was file a certificate of suitability at the time the claim was issued, as is required by Rule 21.5. Instead, she filed it about a month later when the omission had been identified and pointed out to her. And she asked the court to correct her failure. She said she was already a litigation friend, but asked the court to rectify any issues, either by using its power under Part 21.34 to regularise any defect that had arisen from the late filing of the certificate, or alternatively under Rule 3.10b, which is the court's general power to remedy any error of procedure. And the defendants for whom I acted argued that the failure to file the certificate of suitability meant that it was no longer open to the daughter to become litigation friend without seeking an order of the court by way of an application under Rule 21.6. And Mrs. Justice Falk held and made clear that Rule 21.5 set out the only way in which one could become a litigation friend without a court order. And therefore, if one is seeking to rely on the filing of a certificate of suitability, that certificate must be filed at the time that the claim was made, if you're wanting to act as litigation friend for a claimant. And it was pointed out and argued on behalf of the daughter that the rules made different provisions the times in relation to when the certificate had to be filed if you want to act as a litigation friend for a claimant or litigation friend for a defendant. And the judge held, well, that was simply a result of the way the rules have been drafted. But if you wanted to act as a litigation friend for a claimant, the certificate must be filed at the time that it is made. And the judge considered the sensible approach in these circumstances was for the court to deal with the issue by making an order under Rule 21.6 if it considered it appropriate to do so. She left open the question of whether she could also have used Rule 3.10b to fix the failure to file a certificate, but essentially held that in either event, the court would really be needing to address the same substantive issues, which is, does the proposed litigation friend meet the criteria for that appointment? Now, I'm going to be looking at those criteria in a bit more detail in a moment. But before I do so, I'm just going to consider the situations that can arise where things happen, particularly where someone loses capacity in the course of proceedings. So, Joe, could I have the next slide, please? So, if a party to litigation loses capacity in the course of the proceedings, can someone then step in and act as their litigation friend without a court order? Now, in the case of a defendant, the answer seems to be yes, because the certificate of suitability only has to be filed at the time when the litigation friend or proposed litigation friend first takes a step in the proceedings on behalf of the defendant. So if the defendant's proceedings loses capacity, the litigation friend, provided that they don't purport to do anything prior to the filing of the certificate of suitability, can file the certificate and then carry on acting as litigation friend. And the same would go for a deputy who's acting for a defendant. They just need to file their order authorising them to act at that time. However, the position is more complicated in relation to a claimant, because the rules say, and this is Justice Fulker's held in Hinduja, that this means that you can only become a litigation friend for a claimant if you file your certificate of suitability or your court order at the time when the claim is made. So it would seem that if a claimant loses capacity, it is not possible then to become a litigation friend for that claimant without a court order being made under Rule 21.6. Now, this has an important implication if you're acting as a deputy. If you are acting as a deputy, you only have to file your order. You don't have to file the certificate of suitability. And that means if you're a deputy who's going to act as litigation friend for a claimant, you don't have to provide, in the normal course of events, the undertaking to pay any costs that the protected party may be ordered to pay, which forms part of the certificate of suitability. If you can only be appointed under Rule 21.6, the rules make clear you have to meet all the criteria under the certificate of suitability. So you would, in those circumstances, it appears, have to provide that undertaking. So if you are a deputy who is who wants to act for a claimant, it is absolutely essential you get your certificate of suitability in at the time the claim is made. Otherwise, you may be required to provide an undertaking in costs, which you wouldn't otherwise have to do. That was not an issue that arose in the Hinduja case, so the judgment shouldn't be treated as being definitive on that point, because the litigation friend there wasn't someone who was a deputy. But this is an issue that may arise in some other cases, and I know it's something that Sarah, I think, has had to think about. Yes,
and a point that occurred to me on that argument was that in 21.42 of the rules, they provide that a deputy with authority to litigate is entitled to be a litigation friend. And I wondered then what discretion really is left, or how that's compatible with the apparent discretion to appoint under 21.6 if that analysis that you've outlined in Hinduja is right as regards deputies.
No, I mean, it's interesting, and I mean, I think we can both agree that Rule Part 21 is not particularly happily drafted. No. I think as a general proposition, the court that is seized of the litigation always has power to remove a litigation friend under Rule 21.7. That's a point I'll turn to in a moment. So my view, I think, would be that, notwithstanding the use of the word entitlement in 21.4, it's not an absolute entitlement. It gives you priority over others, but it doesn't, I think, prevent the court from refusing to, the court that sees the litigation, from refusing to appoint a deputy who's been authorised by the Court of Protection for its litigation friend. The court can always stop that person from acting, I think. A couple of other points to note is that there is a distinction between protected parties and children. If a protected party regains capacity to litigate, the litigation friend's appointment doesn't cease automatically, but will continue until there has been a court order terminating their appointment. That can be contrasted with the position of a litigation friend for a child. If that child attains the age of 18, the litigation friend's appointment ceases automatically. Now, I just want now to turn and consider the question of the grounds on which the court either appoints a litigation friend under 21.6 or terminates their authority under 21.7. The criteria for appointment, as Sarah's already indicated, and this, Joe, actually is a moment for a new slide, please.
I think you may be on the wrong slide. Sorry to interrupt. I think you were on the right slide before, Joe. If you go back, that's the right one.
Right, brilliant. Thank you. Sorry. The criteria for appointment is that a person may act as a litigation friend if they can fairly and competently conduct proceedings on behalf of the child or protected party and have no interest adverse to that of the child or protected party, and they're willing to give the costs undertaking. Now, Sarah's going to look at the costs issue in just a moment, but the requirements, the first two requirements, the not having, as the being able to fairly and competently conduct the proceedings and not having an adverse interest, have been decisions that have been considered in a number of cases. The first condition, fairly and competently conducting the proceedings, is focused very much on the personal characteristics of the litigation friend, and will normally require the court to consider whether that litigation friend has the skill, ability and experience to be able properly to conduct litigation of the type in question. And the second condition, having no interest adverse to that of the protected party, looks at the extent to which the proposed litigation friend's legal interests diverge from those of the protected parties. Although the authorities demonstrate that in practice, courts do not always distinguish very carefully between the two, and there certainly seems to be an overlap between the two conditions. Now, it is possible, where there is an application for a litigation friend to be appointed, for the other party to proceedings to challenge them, or indeed to seek, once they've been appointed, to seek their removal. I should say that possibly needs to be approached with some caution, and certainly in the case of Folks and Fazy, a 2006 case, the Court of Appeal cautioned against satellite litigation over the issue of whether somebody was a protected party, and made the point that the having a litigation friend in place was in fact something that was generally to the advantage of the other party to the proceedings. Now, looking at the question of these two conditions, the authorities have been considered in a number of cases. As already mentioned, they were considered by Mrs. Justice Falk in Hinduja. They've also been considered by Master Clark recently in the case of Keyes and Parkinson, which was a 1975 Act claim relating to the estate of the late Lord Parkinson, and also by Mr. Justice MacDonald in an administrative court decision called R. Rakib and Bart's NHS Trust, which is a 2019 decision. Now, looking first at the first requirement, whether the litigation friend can fairly and competently conduct the proceedings, the authorities probably demonstrate the following points. Firstly, a litigation friend is not a mere cipher. They are under a duty to acquaint themselves of the nature of the proceedings, to take all due steps to further the interests of the protected party, and to make decisions as to future conduct of the proceedings in the light of proper legal advice. Their job is not to do simply what the lawyers are telling them to do. They have to weigh up that advice from the legal representatives and then make the decision. A litigation friend must be able to exercise independent judgment on the legal advice that he or she receives. And coming from the decision of Rees, which I've just mentioned, the litigation friend must be able to approach the case with objectivity. Now, the meaning of this word objectivity was something that cropped up again in the Hinduja case, and Mrs. Justice Falk deals with it in her judgment. She held that Rees related particularly to its facts. In the Rees case, the substantive issue before the court was whether it was in the best interest of the child to travel to Italy for medical treatment. The treating hospital where the child was concerned that the then litigation friend's religious beliefs meant the litigation friend couldn't take a balanced and even-handed approach to determining where the child's best interests lay. However, in the Hinduja case, Mrs. Justice Falk made it clear that objectivity doesn't mean that litigation friend should be independent or impartial as between the parties to the litigation. Rather, the objectivity required relates to the litigation friend's ability to act in the protected party's best interests, and in doing so to listen and to assess the legal advice and properly weigh up the relevant factors in making decisions on the protected party's behalf. In relation to the second question, to ensure that litigation friend has no adverse interest, the authorities tend to demonstrate that what is or isn't an adverse interest is of necessity very specific to the facts of each individual case. But they establish that the relevant inquiry is directed towards the conduct and outcome of the litigation for which the individual is to be appointed. And normally it's not appropriate to search outside the bounds of that litigation for some other factor that might suggest a conflict of interest between the position of the litigation friend and the protected party. It's not enough that the litigation friend has their own interest in the outcome of the proceedings. The interest must be adverse to that of the protected party. But it's been recognised from various cases, and the decision of Lawrence Rabinovitz QC, sitting as a Deputy High Court judge in a case called Davila, even where the interest of the protected party and litigation friend may run in parallel or even coincide, that doesn't necessarily preclude the possibility that their interests might diverge and become adverse. It shouldn't be assumed, from Mrs. Justice Falk's judgment in Hinduja, that the fact that a relative has a financial interest means they're necessarily debarred from acting as a litigation friend, but equally the existence of that financial interest in the outcome of the case may be something that could constitute an adverse interest. Finally, an important decision of the Court of Appeal in a case called Nottinghamshire County Council and Bottomley makes clear the existence of an adverse interest doesn't require any wrongdoing or potential wrongdoing on the part of a litigation friend. That case was a personal injury claim where the litigation friend was the director of social care for a relevant local authority that was looking after the claimant. There was no suggestion that the litigation friend had done anything other than an excellent job in looking out for the claimant's interests in proceedings. However, the form and quantum of the PI claim and the terms of settlement were matters that could affect the local authority's obligations to charge the protected party for the support that they were providing her with. And the Court of Appeal held that litigation friend, as an officer of that local authority, wasn't in a position to provide independent judgment on the advice. And they stressed that it was important not only that litigation friends shouldn't have a conflict of interest, they should be seen not to have a conflict of interest as well. That's all I'm going to say on those issues, and I'm going to hand back to Sarah now to deal with the third question, the undertaking and costs, and indeed some costs matters more generally.
Thanks, David. And Joe, could we move to the next slide, please? Thank you. Well, you've gathered already that being a litigation friend is quite an onerous responsibility, and that is accentuated really when one considers the costs, risks and the costs implications that a litigation friend might be exposing themselves to by accepting such an appointment. There are really two places that one has to look, or two places to consider for the costs implications of a litigation friend acting as such. The first is under Part 21 of the rules, and then the second is the sort of general common law position, which I'll come on to. But I'll start with looking at what the rules say about the liability of a litigation friend for costs. And we've touched on the first two bullet points already, really, which is that any litigation friend acting for a claimant will have to give an undertaking as to costs unless they are a deputy who has been authorised to litigate and who files their order of the Court of Protection with the civil court at the time the claim is made. So the undertaking to pay costs indicates that a litigation friend will be personally responsible for costs ordered in proceedings where he's acting for a claimant. He may or she may be able to rely on an indemnity under Part 21.12 in respect of any assets recovered in those proceedings if they've acted reasonably. In any event, as I'll come on to mention, any litigation friend will want to make sure that they have appropriate indemnities or security for their costs if they want to accept this appointment of being a litigation friend. The other thing that the rules say about costs is when the liability for a litigation friend's costs might come to an end. The rules have really only one thing to say about that, and it's quite limited in its scope, and that is that the liability for costs of a litigation friend will continue until either he or the person whom he formerly represented serves notice on the other parties that he ceased to act as litigation friend, and that's found in 21.96 of the rules. But that situation only will arise where you have either a child who's reached 18 or a protected party who's regained capacity. So it's quite limited in its scope, and certainly in practice, I haven't had to deal with one of those situations. And I think it's arguable, and in fact, it's likely, in my view, that a litigation friend might well still remain liable or possibly liable for costs which have been incurred during the period when he acted as litigation friend. And certainly under the common law position that I'll come on to consider, that's still a risk for a litigation friend. So could I turn to the next slide, please, Jo? So the rules, that's what the rules say about costs, and you might read them and think, well, it's only going to be a problem then for a litigation friend if you're acting for a claimant in proceedings, because only in those circumstances do you need to give an undertaking. And indeed, if you're a deputy acting for a claimant, perhaps you don't need to worry at all, because you don't have to give that undertaking provided you file your order at the right time. But you would be mistaken in taking such an optimistic view of the position, because there's a decision of Mr. Justice Morgan in the High Court in Barker and Confiance, which I mentioned there, which decides that a litigation friend really stands in the same position as any other litigant as far as the costs of litigation go. It's not the equivalent of making an order under Section 51 of the Senior Courts Act against a third party who's been involved in litigation. The litigation friend is really to be treated as if they were the litigant themselves in proceedings. It's probably worth just outlining what the sort of background to Barker and Confiance was. It's a case which arose out of long-running litigation, sometimes called the twin benefits litigation, It was effectively a challenge by two minor children acting through their mother as litigation friend to an earlier compromise that had been reached and approved on behalf of those children who were being represented in a rather indirect fashion by a former litigation friend. So children challenging a compromise through mother as litigation friend, that challenge failed, and the decision of Mr. Justice Morgan was really about the costs implications of that challenge. So the mother had acted, what she'd done was she'd applied for her children to be joined as parties to the formal proceedings and joined as defendants, and asked for an order really reopening the compromise. She'd acted as litigation friend, having filed a certificate of suitability, but she hadn't given the undertaking in Rule 21.43 because she said her children, whom she was acting for, should be treated as defendants in the original litigation, and therefore she didn't have to give the undertaking. And so when the challenge failed and the argument arose as to costs, she said, well, really, I'm not liable. Look at the rules. I didn't have to give an undertaking, and I shouldn't be made to subject to a personal costs order. And Mr. Justice Morgan dismissed that argument and did impose a costs order on her. And effectively, as I've said and as outlined on the slide, he took the view that it didn't really make a difference whether the litigation friend acted for a claimant or for a defendant in proceedings, that they had a really freestanding potential liability to pay costs if the court so ordered. So he made an order for costs against the litigation friend. He declined to make an order against the minor children themselves, although he said it would have been in principle open to him to do so, but as they haven't been responsible for the application and had gained nothing by it, he would not make an order against the minors. And I think it's fair to say, I mean, that first of all, as I'll come on to mention, Barker has been subject to an appeal, and the appeal has been heard, but as I understand it, not yet determined. Certainly we couldn't find a judgment on it. And the reasoning is possibly fair enough when the litigation friend is the author of the litigation, but that won't always be the case. And maybe that will be reflected in the order that the court makes. But could we go on to the next slide, please, Joe? But there is a real question, it seems to me, about Barker and how really it's consistent with the requirements in 21.43c about a claimant having to give an undertaking, but not a defendant. How is that consistent with a litigation friend for either potentially being liable for costs? The argument was raised before Mr. Justice Morgan, but he dealt with it by simply saying that he didn't accept the submission, that 21.43c wasn't a limit on the court's powers, that they supplemented the general principles and didn't detract from them. I suppose there's also a question how it's consistent with the fact that when a claimant succeeds in proceedings and a costs order is made, claimant who's a protector party or a child, the court makes the order in favour of the claimant himself, not the litigation friend, and then the litigation friend indemnifies themselves from the recovery. So there's a sort of slight mismatch there potentially in terms of the treatment of the litigation friend in relation to costs.
Can I intervene there, Sarah?
Yes, please.
I mean, it may be that I would entirely agree with all those points on the rules. I suspect what Mr. Justice Morgan had at the back of his mind, though, was that where he had a litigation friend who he wanted to make a costs order against, he was, one way or another, costs are always in the discretion of the court. And it would always have been open to him, and I think he mentioned this in his judgment, to join the litigation friend as a party to the proceedings in their own right, and then make a third-party costs order against them.
Yeah.
And having looked at his judgment, I also rather felt he was perhaps just trying to elide those two steps and get to the conclusion he intended to in one bound.
Well, possibly, except the odd thing about Barker is they had made that application to join. I mean, everybody, until he took this line, was proceeding on the basis that it was necessary, I think, to go down that sort of third-party costs route. But as you say, he wanted to sort of make it sort of a quicker approach. Anyway, it will be interesting to see. As I say, the hearing has taken place, so as the slide indicates, watch this space. The second bullet point there is just, well, whether this analysis applies to a litigation friend for a protected party. It does obviously apply to minors, but is there any difference? Well, I think the answer is there's no difference in principle. There might be some factual differences though, because first of all, the protected party might be more the author of the litigation than a litigation friend for a minor would have been. The protected party might have done the things which give rise to the litigation and might even have commenced the litigation themselves before losing capacity. So the protected party might be more obviously responsible for the costs. And the other point is a practical one, that a protected party may be more likely to have assets to satisfy a successful opposing party than a minor. So the opposing party might not be so interested in getting an order against the litigation friend. But I think as a matter of principle, the analysis should be the same. Can we go to the next slide, please, Joe? So where does that leave us? Well, I mean, as far as a litigation friend's concerned, number one step to take is to make sure that before being appointed or filing your certificate of suitability, you are sure that you are adequately protected, both in relation to the costs that you will incur sort of on your own side, but also in relation to the prospective liability you could have if an adverse costs order is made. So that's the first step. But well, what happens if you can't? I mean, in a case where you're acting for a defendant, things might be a little bit easier, because the claimant, in order to get their litigation going, is going to need to get somebody appointed as litigation friend. So it may be ultimately that the claimant has to give some sort of undertaking as to the defendant's costs, just in order to get through to a judgment. So defendants are in slightly different position. But if you're a claimant and your litigation friend can't get enough security for their costs, what are you going to do? You need a litigation friend. Litigation friend isn't prepared to act, isn't prepared to give an undertaking, isn't prepared to take a risk of a personal costs order. And it's a really tricky point. Can the court dispense with the undertaking under 21.43? I mean, it's quite mandatory in its terms, but the court does have general sort of case management powers under 3.12n to take steps which further the overriding objective. There is a case called Bradbury and Patterson, which suggests the court might be able to fashion some sort of arrangement in relation to costs using that general case management power. Can the court relieve the litigation friend prospectively from the liability to the other side's costs? Well, it's not a sort of classic preemptive costs application, because you won't be able to show that ordinarily the court is bound to make a costs order in your favour, regardless of the outcome of the litigation. But again, I mean, what else is going to happen? How else is this litigation going to proceed? And I think an important point to remember is that the party to the litigation, that is the protected party or the child, is not being relieved from liability for costs. It's only the litigation friend. So in a sense, the other party isn't in a worse position. They can still seek to get a cost order against the actual party to the proceedings, even if the litigation friend is not prospectively liable. And that sort of takes me on to the third point, that if if there isn't any power to dispense with the undertaking or to relieve prospectively a litigation friend of costs in the sort of situation I've given, where you've got somebody who simply can't get a litigation friend any other way, I mean, would that amount to a breach of the party's Article 6 rights, the right to a fair trial, or Article 14 rights, the protection against discrimination? I think, again, that there isn't any direct authority on it, but arguably, yes. I mean, if there's a blanket inability under the rules to dispense with the undertaking or to relieve from costs, although interferences, if you like, with the Article 6 and Article 14 rights can be justified, they've got to be justified by a legitimate aim and be done so in a proportionate way. And I do think it's open to argument that a blanket prohibition on either of those two things might fall foul of Schedule 1. But, you know, that will be an argument that somebody will have one day, I have no doubt. So thank you very much. That's all I wanted to say. I don't know, David, if you've got any...
I was just going to add one final thought on that point, Sarah, which is if the protected party has got some money already, then the litigation friend can always sort of do a quasi-Beddoe application to the Court of Protection for authority to use the protected party's money in the litigation and essentially to protect themselves from the costs risk. But obviously that only works if the protected party has got some money already. And in a number of cases, perhaps if you're bringing a personal injury claim on behalf of somebody who's impecunious but has sustained a serious injury, that isn't an option.
Absolutely. And I mean, one other solution, there may be other solutions. For example, in the context of a 75 Act claim, you could consider making an application for interim provision in order to allow funding of costs. That might be another sort of way through. But those are rather sort of case-specific considerations.
Very much so.
Now is your opportunity if anybody wants to throw us in some questions. I don't think we've got any at the moment, but should we give it a minute? And if not,
we can give it a minute to see if anybody's got some burning issues. But otherwise, I mean, this is a fascinating area, not least because I think Part 21 has not been well drafted, and some of its problems also arise from the fact it was originally drafted, of course, when the CPR came in 1998. Which was before the Mental Capacity Act and before the sea change in how capacity is addressed by the Mental Capacity Act. And as a result of that, when the MCA came in, the rules were changed. Well, they were amended, but there wasn't a sort of wholesale revision. I think some of the rules sort of slightly reflect that problem. We have a question, which is how do the rules then apply on a counterclaim? And I think the answer to that is that that's a step within the proceedings, and so at that point, one would need a litigation. Well, if you're acting for a defendant on a counterclaim, and the defendant lacks capacity, then you would already have needed to have filed your certificate of suitability at the moment that you file your defence or acknowledgement of service.
Yes, and I suppose the other point in relation to the undertaking as to costs, I mean, I think you would then be treated as a claimant as far as the counterclaim went, and so have to satisfy, provide the indemnity at that stage, or provide the undertaking at that stage. Great. Well, thank you very much, everyone. As I say, we do appreciate your attention this afternoon and coming along. You can spread the word if anyone's interested. The recording of this will be on our website and also on our YouTube channel, so you can watch it again, or your colleagues who haven't been able to watch it today can pick it up then. But thank you again. And
thank you very much.